welcome to this Invest in Lombardy webinar. Welcome from Milan. Let me first of all introduce our distinguished guest today that will go through the today topic of patent box, general rules and current impact. We have today with us the law firm Pirola Pennuto Zei, with me Piero Marchelli. Good morning.
Good morning.
And Francesco Mantegazza.
Good morning.
Good morning. I will first of all just give you a few insights about doing business and investment in particular in Lombardy region. Today we will definitely talk about the patent box reform that is positively affecting the Italian doing business environment, but I would like to provide you some information specifically about Lombardy region as the leading region for business and investment, and in Italy an ultimate getaway for investment in Italy. When we talk about Lombardy, we talk about the leading region, as I said, in Italy, representing 1/4 of the Italian GDP. If Lombardy was a country, it would be the 6th country in Europe. Just to give you the idea of the importance of Lombardy for especially for foreign companies that want to do business and investment in Italy. 800,000 companies, one of the 4 European engines, together with Catalonia, Baden-Württemberg, and Rhône-Alpes, representing, as I said before, a getaway for investment and business in Italy. We want to show you in particular which are the most important sectors in Lombardy region. And when we say Lombardy region, is of course a way of showing Italy at its best. As you see from the slide, Lombardy represent they are open to enter Italy, and as you see, there are several sectors where we have excellencies. We have companies that represent. This is not simply in Italy, but in Europe and all around the world. So I just mentioned in the slide, you see some of them, so life science, engineering, ICT, and media, and design and fashion, as those sectors where innovation and creativity are better expressed, and where Italian companies, in particular companies from Lombardy, represent excellencies at international level. So for example, when it comes to life science, we see that Milan has one of the highest percentage of companies in terms of both in terms of number of companies and numbers of employees in biotechnology and in chemical sectors. In terms of engineering, we have 4 excellence in districts and a number of companies that is among the highest level at European level. Same with ICT, with Milan, one of the most wired cities in Europe, and technology parks that express high level of specialization in both in employees and in terms of companies on the field. And of course, last but not least, the excellences which is traditionally very well known abroad of design and fashion industry, where the creativity and the value added of the Italian know-how is definitely at its best. A couple of slides specifically related to innovation. Lombardy is definitely an innovative region and leads the way in Italy for companies that want to set their business in Lombardy and want to then grow and increase the presence all around the country. 500 research centers, more than 10 technology clusters, 6 technology parks, with a very interesting figure for 2014. Lombardy accounted for more than 3,000 patents registers in Italy, over an amount of 9,400. It means that around 31% of the Italian registered patents have been registered in Lombardy. Just to show you the importance of the region in terms of patents. In particular, you see from the slide a few figures on the creative and cultural industry in particular. Lombardy ranks among the first position all around the European Union in terms of workers in this sector. So with almost 200,000 workers, so third in Europe in terms of number of employees in creative and cultural industries. That express one of the sectors where actually patents and creativity are better expressed. You see from these slides that Milan, we always mention figures of 2014, so last year, 2,300 patent registers, the highest rate in Italy for Milan province, 400 European green patents, so with a very, very, very relevant increase specifically in this field of green sector, let's say, so waste management, renewable energies, and energy efficiency conservation. It's interesting also to see that Lombardy represent an absolute excellence all around the European Union for advanced manufacturing, micro and nano electronics, and advanced material. Those are the sector where we have the highest number of patent registers in the last 10 years, so between 2000 and 2014. Let me say that together with the high level of innovation of our companies comes the high level of education of our region. 13 universities, excellences institution, for example, design, engineering, fashion. This is one of the, definitely of the asset that we consider strategic for our companies to keep growing and for our territory to become more and more attractive for foreign companies that want to do business and investment here, and for foreign people, for foreign brains that want to come over and consider Milan, Lombardy, Italy as a destination of business and activity. I just mentioned the innovation and the education as the two pillars of the current strategy, and I would say of the 2014-2020 strategy of the region, especially in terms of European strategy for growth. Those pillars are the key factor, I would say, the real assets of our SMEs. These slides, it's very interesting because it's showing how, I mean, not just the Lombardy SMEs, but Italian SMEs have a very high level of return, both in terms of gross margin and in terms of turnover compared to the European average. And this is very much related to what I just mentioned before. So the high level of innovation of many of those companies and the high level of the employees, high specialized employees of those companies. This is just one example. I mentioned before that the high-tech manufacturing is one of those sectors where the numbers of patents registered is higher. This is another example. Those are data from Eurostat and FDI benchmark of Financial Times, showing that Lombardy is specifically for technology manufacturing. But we have compared from our point of view of Invest in Lombardy Observatory, we have shown how there are like 20 sectors where Lombardy is leading the way in Europe in terms of number of employees, high-skilled employees, so engineering skilled workers, compared to other leading regions in Lombardy. So we're talking about Ronaldo, we're talking about Catalonia, Stuttgart, Darmstadt. So the comparison, so we are competing with the main region in Europe. This mix is very important to show cost qualities matrix. So it's not just a matter of level of specialization of those employees, but it's also a matter of cost. Milan, we also show in the example of Tuscany, another important region in Italy. But as you see from this slide, if we combine cost of the employees and quality of their activity, of their labor, the result is that Milan is the leading region, Milan area, so Lombardy region is one of the leading region. And in some sectors, this is the example you see in wood manufacturing, is the leading region in Europe in terms of cost-quality combination. Very last word on what we do for foreign companies that want to do business and investment in Italy, starting their activity from Lombardy. Invest in Lombardy is a public agency investment promotion agency of the Lombardy region inside the Milan Chamber of Commerce, and the importance of the network with all the public institutions and the private professionals on the field. Pirola Pennuto Zei is a strategic partner of our project, helping foreign companies to find the best conditions of support to do business and investment here. It's been for the last 4 years the best way for us to help companies, foreign companies that want to set their business or increase their presence, their existing presence on the field. So we are sure that with our activity that is mixing the public support and the private professional competences, we will be able to support your companies, support foreign companies to better consider Lombardy and Italy as a suitable destination of business. It's all from my side. I would now give the floor to my distinguished guest that will in particular talk about patent box and how this reform is positively giving opportunities for companies to make advantages out of it in their business. So Piero Marchelli.
Thank you, Marco. Good morning, everybody, and thank you for participating to this webinar conference about Patent Box. And first of all, I need to thank Marco for his speech, in which some data have been specified. And I remind the 9,000 patents in Italy, approximately 1/3 of which is in Lombardy. Well, these patents could have, or the number of these patents could have been even higher than the one that has just been mentioned by Marco, to the extent the rules on patent box would have been enacted before. There is a lot of speaking about patent box now. There is even some level of confusion because nobody or several people do not really understand the impact and how this works. Well, let's just go through the general overview of the reason or a reason why the patent box has been enacted. At the end of the day, the Italian government realized that an enormous value must be given to intangible assets which are developed by the countries, by the companies, or by the entrepreneurs. Even the persons, physical persons, can take benefit of the patent box. This was not duly appreciated in the past, but finally the legislator ascertained that it would have been beneficial to our country if a certain regime which could create a more favorable environment, tax environment, would push the entrepreneur to keep their patents in Italy instead than registering them or filing them abroad due to the more favorable tax regime that it could have been found in other countries. The number of patents that you mentioned could have been higher. Why? Because several entrepreneurs filed abroad their patents, not finding here the appropriate environment, the framework that could grant them some beneficial measures. Therefore, the legislator decided to put in place some measures which were aimed and which are aimed at promoting the localization, we can see, promoting localization of intangible assets in Italy, even granting the framework under which the entrepreneur can bring back to Italy what was initially exported, to promote the permanence of these patents in Italy, and to stimulate the research and development, which is one of the engines through which Italy, but most of all Lombardy, has reached the goals and the levels that Marco was mentioning before. Therefore, it has been created an attractive Italian market for everybody who's investing in intangible assets. Italy is, in any case, not the only company, the only country that enacted such a rule. We can see from the chart that you can have on your display that similar rules have been enacted in the Netherlands, in UK, in France, in Belgium, in Luxembourg, and in Spain. But I would draw your attention on what the specific national legislations mentioned here, or in the countries mentioned here, address to. In most of cases, they only address to patents. Only Luxembourg addresses and created a favorable environment, not only for patents, but also for trademarks. According to the OXE directive suggestions, trademarks were not something on which it was considered worth to invest or to extend such kind of normative, because it was considered as an intangible asset on which it is not so necessary to invest a lot, and not such an intangible asset that can originate big expenditure in research and development. This is not true, but this is not true mainly for our region. Just consider old-fashioned companies. In those cases, the brand, the trademark, is really the richness, is really something which is worth expenditure in research and development. Sometimes products are bought not because of the product itself, but for the trademark they bear. So Italy decided that also trademarks were to fall under this new legislation and under this tax normative. So the legislation was enacted with the Stability Law of 2015 and was afterward amended in March 2015, including also the trademarks and equivalents, all those which are equivalents to patents. Then there was an implementation of certain rules and by the Ministry of Economy and the Ministry of Finance, which highlighted or defined in a better way which was the level of tax benefit that could be granted to investments made in patents. And at the end of the day, it was also approved the form by which the companies can opt to adhere to some tax regime. Because we must remember that this legislation is not applicable per se. It is applicable to the extent the company involved, the entrepreneur, decides to opt for this tax regime and therefore to take benefit of it. A specific request must be filed, a ruling can be filed so that we can know in advance which will be the benefit and what we will spare from our taxes. But this, of course, depends on the filing that is going to be made. And this is important why, this is the reason why it is important that the filing is made in the proper way. First question, at the end of the day, what is eligible to be protected under the patent box? Well, all intangible assets which can fall within a protection because, as patent, as trademark, or as know-how. And this is another difference with certain other legislations of other countries where the know-how is not falling within the application of this law. So the patents, either required or granted, it is not necessary that patents are granted actually, but if a filing has been made to obtain a patent, this is already an eligible asset for the benefits of the reform, and patents concerning inventions, biotechnologies, new plant varieties, utility models. So we are going to touch most of the sectors where the companies in Lombardy are much more active and are at the top of their field. As well for the trademarks, they can be eligible assets to the extent they are required or granted. Then we can apply this rule also to software, which is not protected by the Code of Intellectual Property, but the laws on protection of copyright. But, as I was saying, as well, the designs and the corporate information, technical industrial experiences. So the know-how. I think that everybody of us has always been facing the requests of certain entrepreneurs who were willing to defend their know-how, something which is extremely difficult to define because it depends on the sector, it depends on the kind of, or better, of the bunch of experiences and specific knowledges that an entrepreneur has. In this respect, also these intangible assets can be protected. What cannot be protected? It cannot be protected what cannot be protected under an Italian law such as the copyright or such as the Code of Intellectual Property Right. But it must be said that it can be protected, something that is not falling within those Italian law, but is protectable according to foreign law. So if any patent may be not accepted in Italy, it could be filed in another legislation where it could be eligible, for protection, And this asset, either protected under a EU regulation, a regulation of another country part of the EU, or protected according to a treaty or to a specific convention, well, this asset will be protected in Italy as well. To the extent to specific intangible assets, which are per se eligible, are to be considered jointly for their application in a process or for the production or manufacture of a certain specific product, according to this law, these two eligible assets should be considered for the purposes of the law as one sole asset, taking benefit from a tax perspective of this legislation. And who would be entitled to apply for this specific legislation? Well, as I said before, companies, individuals who realize their business income, which is a subject to IRAS and IRAP, so they are carrying out a commercial activity or industrial activity, independent if they are companies, incorporated companies, companies with legal personality or not, so everybody. But not only this, even foreign companies. Foreign companies may have and may decide to take and to bring their patents in Italy, taking benefit of this law, to the extent those foreign companies are incorporated under a legislation which provides for a treaty for against double taxation, and there is a level of transparency, so an exchange of information with the Italian authorities, or even a branch or a permanent establishment that, as we all know, in Italy is considered not furnished of legal personality. Well, it could fall within this legislation, which is considered the only legislation that actually gives a great help to companies after several years of zero, to the extent that in these branches are allocated the patents that are seeking for protection. I'm going to leave the floor now to my colleague, Francesco Mantegazza.
Thank you, Piero. Good morning to everybody. As Piero was saying, the range of eligible assets is quite wide, and the range of persons that can opt for this tax regime is quite wide as well. Conceptually, what is the idea underlying the patent box? Basically, the idea is to exempt a part of the income that arises from the use of intangible assets. The portion that is eligible, the portion of the income that is eligible to be exempted is set as to 30% of the relevant amount for fiscal year 2015, that is the first fiscal year of applicability of this tax regime, 30% for 2016, and 50% starting from 2017 onwards. The idea, as I was saying, is to exempt the income arising from the intangible assets and not just the revenues. So in other words, it is necessary to identify both the revenue side that relates to that intangible asset, as well as the cost side that is of relevant for that asset. The main condition to get and to have access to the tax regime is the existence of research and development activities, and therefore of costs arising from said activities. The idea underlying the regime is that the research and development activities can be carried out either internally by the company or externally based on agreements with universities or other similar organizations, the purpose of which is to develop intangible assets. Costs can also rise from transactions with unrelated parties, and to a certain extent, we'll see it later on, based on transactions with related parties. For the purpose of the patent box tax regime, it is quite important to distinguish two basic cases. The first one is the case in which the intangible assets are directly used by the company, and the second one is the case in which the assets are concessed and used to other companies. With respect to the first case, well, the exercise it is basically to identify as part by extracting from the general accounts and the general figures relating to the business of the company those revenues, those implicit revenues and costs that do relate to the intangible asset that is used as part of the business activity of the company. From a pure So this is, I would say, an exercise that has to deal with tracking and tracing not only activities but also items of costs in this case. From a pure tax perspective, it is then necessary to file an application to get an advance ruling so that the amount of the positive item of income that can be attributed to intangible assets can be agreed with the tax authorities based on a procedure that is basically relying on the exchange of information between the taxpayer and the tax authorities and the identification of a mutually agreed amount of positive items of income. The other case is the case in which the intangible assets are given in use to third parties, so there is a licenses agreement in place, and in that case the income or better the revenues that can be taken into account to determine the income is given by the amount of the royalties that are earned by the company as a result of the licensing, and as opposed to the actual costs, direct and indirect, that are incurred by the company in relation to that intangible asset. While talking about cost, we have to say we are talking about cost, the deductibility of which is recognized by tax provisions based on the general tax framework for business income. In the case assets are not used internally but are object of licenses agreements, the ruling procedure is not mandatory, i.e. it is a simplification from the taxpayer perspective, so it is not bound to go before the tax authorities and agree in advance the amount of the positive items of income can be attributed to the intangible assets and to a certain extent less burdensome. The ruling procedure is nevertheless optional in the case the relationship having as object the intangible assets are carried out with related parties. So in that case, there is the possibility to agree in advance with the tax authorities whether or not the amount of the positive items of income arising from intra-group transactions can be recognized for the purpose of the patent box regime. What is the amount, how we calculate better the income the portion of the income that can benefit from the exemption? Well, the idea underlying the patent box is basically to link on one side the costs that are incurred by the company for the development of the intangible assets to the revenues that can be generated by that intangible assets, and ultimately to the actual capability of the costs incurred to create and develop the intangible assets in the hands of the company. The law sets out a ratio that has to be calculated for the purpose of defining, as we will see later on in a very simple example that we have included in the slides, to calculate the amount of income that can be exempt. The ratio is made, as far as the numerator is concerned, by the amount of qualifying costs for research and development. So basically the costs rising from activities carried out internally or externally with universities and other similar organizations. So I have to move closer to Piero, sorry. And as far as the numerator is concerned, the total costs that are incurred for the development of the intangible asset. The numerator can then be increased up to 30% of its overall value with costs that are incurred for the acquisition of the intangible asset or that arise from agreements with group companies in relation to the development of the intangible asset. We have to say that it is immediate to understand that the intention is to stimulate a constant investment in the research and development activities, to the extent that if during a given fiscal year no activities are carried out, then in that fiscal year there won't be any income that can be exempt from taxation. How the ratio is calculated? Well, of course, the idea of creating a clear relation between costs, intangible assets, and revenues in accordance with the approach that is also adopted at the OECD level is quite challenging for companies, to the extent that it requires the implementation of systems of tracing and tracking capable of putting actually in relation the costs with the intangible assets that are created, which is not necessarily an easy exercise, in particular in those cases in which several intangible assets are put together and are basically working jointly for the purpose of producing a certain product or carrying out a certain activity. So in the view of facilitating the first years of implementation of the tax regime, basically the law allows the taxpayer to calculate the amount of the cost to be included in the ratio by having regard to the total amount of costs incurred with respect to all intangible assets, so without the necessity to actually find the actual relation between that cost and a given intangible asset. The idea is to give time, and basically to give 3 years of time to taxpayers to bring their systems, even management accounts, in line with the necessity to track and trace the costs. Another tax advantage arising from the patent box regime is the exemption of capital gains that may arise from the sale of the intangible assets. Said capital gains can be fully exempt from taxation, provided that at least 90% of the consideration that is earned by the company from the sale of the asset is then reinvested in qualifying research and development activities that have as object other intangible assets. So the idea is to create a chain and a sort of continuity over time in terms of new investments into new intangible assets. The investment has not to be performed in the same fiscal year during which the sale is realized. There are two fiscal years, three fiscal years, because it has to be performed by the end of the second fiscal year following the year of the sale. So there is also time for taxpayers to plan and decide where and if the amounts earned has to be reinvested. In the case the capital gain arises from transactions carried out with related parties, then in this case the ruling procedure has to be carried out as a matter of fact to have the amount of the capital gain validated from the tax authorities. Well, as Piero was saying at the very beginning, the tax regime will be effective starting from 2015. Very recently, yesterday, we have had from the Italian tax authorities guidance as to how the option for assessing the patent box tax regime has to be carried out for 2015. And I think we may take note of the fact that considering the limited time available to taxpayers from here to the year end to exercise the option, the approach by the tax authorities has been to give the taxpayer the possibility to opt for the tax regime in a quite simple manner during December, so by the end of the year, and then giving the taxpayer more time to evaluate how the ruling procedures, where the ruling procedures are necessary, can be carried out with the tax authorities and what could be the result of these ruling procedures before taking the final decision as to whether or not the patent box regime is actually a suitable option for that taxpayer. We have had a quite significant clarifications issued yesterday. We and as the rest of the market, we are still going in depth into this guidance that, as a first impression, confirms a lot of, clarifies a lot of the points that were still under discussion, save probably one, which is the evaluation methodologies that have to be or that can be adopted by the taxpayer to identify the income which is generated by the intangible assets in all cases of direct use. So we're saying that in case of direct use, there is the need to work on the management accounts of the company to identify the income that is generated by the intangible asset. We have to say that the law and also now the guidance from the tax authorities does not indicate precisely or with a minimum level of details what are the criteria that can be used to determine that income. So generally speaking, the idea which is also supported by the law and the comments accompanying the law, that reference has to be made to the general principles adopted at the OECD level in the transfer pricing field with regard to intangible assets, which is a clear reference as to the set of provisions or principles to which one may make reference. It is a bit less of help in practically applying those principles in the case of the patent box regime. Again, generally speaking, we have indicated in the slides some of the methods that are usually recognized as accepted method or generally accepted methods within the OECD TP guidelines. We are talking about the excess earning test method, the premium pricing or the profit split methods. Based on our experiences so far, these are the methods that we are inclined to use while considering patent box for our clients. Of course, this is an area on which we still have to learn a lot from the relationship that we will have with the tax authorities as part of the ruling procedures. This is not probably it is not probably the case here to go into details as far as the methodologies are concerned, but the message is this will represent one of the key areas both in determining if the tax regime is convenient or not, so the actual advantages that can be gained, and also in determining the underlying complexity of the procedure. I was mentioning before, we have a very simple example here of how the income can be calculated. The income that can benefit from the exemption is to be calculated. We have assumed here income arising from the use of the intangible asset of 2,000. So here we are assuming the easier case of intangible assets that are the object of a licensing agreement. We have qualifying research and development expenses of 100, where qualifying, as we were saying, refer to costs arising from research that is performed internally or by universities or other organizations. We have expenses for the acquisition of the asset of 80, and we have research and development expenses that arise from transactions with related parties of 70. As we were saying before, this latter category, i.e. that of costs arising from transactions with related parties, can be taken into account only up to a certain amount, which is kept to 30% of the other qualifying expenses. So going here to the figures, we can determine the qualifying expenses as the sum of 100, so qualifying expenses with either internal or arising from not related party transactions, plus 30, which is basically the amount, the cap which is set for the amount of expenses arising from intra-group transactions. This is the numerator. As far as the denominator is concerned, we will have 100, which is the total amount of qualifying research expenses, plus the cost for the acquisition of the asset, which is 80, plus 70, which is here the total amount of costs arising from transactions with a related party. The result of the ratio is 52%. That means that 52% that the income arising from the asset, which is 2,000, by 52% by, for 2015, 30%, gives the total amount of the exempt income. The ratio of 30% is set out on a temporary basis for 2015. It will be increased to 40 in 2016, and it will be 50 for the following fiscal year. How the patent box regime can be implemented? I think based on what we have seen so far, it is clear that the implementation of the tax regime is not straightforward, to the extent it implies to first identify whether or not eligible assets are present in the company, so that patent box actually becomes an option for the company. There is then a step which is the identification of the income that is generated by those intangible assets, and of course complexity can be differently weighted if we are talking about internally used assets or assets that are granted for use to third parties. We have a further step, which is the step of identification of the research and development expenses that may be taken into account for the purpose of calculating the exempt income. We have another step, which is identifying cases or better understand whether the ruling procedure is mandatory or is an option. And then finally, we have to carry out a periodical monitoring of costs and intangible assets, taking into account that the benefit is allowed in a given fiscal year, provided that in that fiscal year research and development expenses qualifying for the purpose of the regime are actually incurred. So this is to say, in a nutshell, that the implementation has to go through a quite structured process to be approached in due time. Of course, for 2015, we are very close to the end of the fiscal year. On the other side, as I was saying, for those companies that will have to go through a ruling procedure, I would say the last guidance from the tax authorities give a bit more of room for consideration by taxpayers. I think that's it as far as the tax side of the presentation is concerned, and following your two presentations. Thank you.
Thank you, both of you. I just ask the people online, if you have questions, you can ask anything. It might be related to patent box or other information that can be useful. So maybe we just give you a few seconds to think about it, and you can do it directly online through the webinar tool. Let's see if we have already something here. Consider that, so we give you some more time on that. All the webinars we organize have been recorded, and also the today webinar will be available on our online channel, so on our Invest in Lombardy YouTube channel, and webinars, of course. All the materials we have provided today will be at your disposal, so anything you might need, any further information and inquiries from your side is more than welcome. So feel free to ask Invest in Lombardy, and of course with the support of Pirola Pennuto Zei, will be more than happy to help you with that. I mean, being the patent box, brand new legislation reforms that will definitely provide opportunities, but also the need, as our guest today have shown, the need of further support and comprehensions for companies, specifically for the more technical topics. So we might go with this question, which are related to some of the slides that have been shown by Pirola. So if you want directly read those questions and answer, you can proceed.
Let's go with your.
Sure.
This one, maybe you can deal with it.
Okay, one.
Okay, we can start maybe from this one. Okay.
Okay.
The question here is, in case of merger, the merger or contribution of going concern, which is the sort of the option exercised by the company. Well, there is a general principle based on which, in case of this sort of transactions here, I merger the mergers of or contribution of going concerns, the neutrality principle that usually is recognized for tax purposes to these transactions also applies for the patent box tax regime, to the extent that the receiving company, i.e. the absorbing company in the case of a merger, or the beneficiary of the demerger, or the receiving company for the contribution in kind of a going concern, steps into the same situation that was existing in the hands of the contributing or transferring entity. This as far as the validity of the ruling procedure is concerned, where a ruling procedure was necessary or was in any case undertaken, and also in terms of duration of the option and calculation of the 5-year period, which is the period during which the company is bound to the option. I think one important point that has been addressed by the tax authorities in the circular letter issued yesterday is that given that there is actually a different level of complexity for taxpayers that internally use assets if compared to taxpayers that instead make those assets the object of licensing agreements, there was a certain debate as to whether the performance of extraordinary transactions and the mergers, or in particular contribution in kinds, were a suitable option to reorganize a group of companies, create IP companies, having the purpose to develop intangible assets, of course, but also to give them in use to group companies or for parties, so to avoid the obligation to go through a ruling procedure. Well, the doubt in this respect, or what was discussed, is whether or not similar organizations could have been deemed to be abusive of law, having the purpose to avoid the ruling procedure. And the clarification, the guidance from the tax authorities is that per se a similar transaction should not be deemed to be abusive of law, because as a matter of fact it does not give rise to any undue tax advantage, but it is simply modifying the way in which the tax advantage can be reached. Needless to say, the tax authorities have pointed out that they reserve the right to assess whether the level and the amount of the royalties that will be paid within the group represent or not, and are aligned or not with the fair market values, or are in compliance with the arm's length principle set out for intragroup transactions. So, Piero, I think we can move to the next one.
Yeah, there's another question. Which is the discipline applicable to different kinds of intellectual properties that are not subject to protection, but the combined use of which is necessary to finalize a process or manufacture a product? Well, actually, it's as we were saying before, any kind of intangible asset to fall within the law must be subject to patent, either required but not yet granted, or granted. Therefore, to the extent we have different kind of intellectual properties that we combine for achieving the goal of applying them to a process or using them to manufacture a product, both the intangible assets must be per se eligible assets. And in applying the law, the result of these two eligible assets combined together will be that these two eligible assets will be considered as one only. But it is necessary that they both are eligible assets. It cannot be considered, and it will not be relevant under the patent box, the combination between a patent and an asset which is not subject to any protection under any intellectual property law or treaty or convention. So this is the basis. What we are going to, or what the country is going to protect by this law is only what is considered worth of being a patent, trademark, patent industrial, commercial, know-how, copyright, anything like this.
Thank you. If you don't have any other question, I just want to add a final question from my side, from the point of view of the Invest in Lombardy Observatory, that of course is first of all taking into consideration the point of view of maybe we have another company.
Yeah, we have another question.
In case, maybe I can read it. In case of the merger or contribution. Sorry. Could patent box be applied also by an Italian master franchisor or of a foreign franchisor?
Well, conceptually, the entities that can assess the patent box regime are both the owners of the intangible asset, as well as entities that have the availability of the intangible asset based on licenses agreements. So I think the answer here is in principle yes. Of course, it will be a matter as far as, in terms of how I would approach, practically speaking, the question is a matter of understanding the legal nature of the agreement in place, so to make sure it is actually falling within the scope of what is availability of the intangible assets in the meaning of the law.
Just to complete what I was asking you is from the point of view of course, because both Italian and foreign companies are concerned. But if we think about the point of view specifically of the foreign companies, if you take into consideration your experience on the field and what Piero, you were saying at the beginning, so the fact that we could have had much more patents registered in Italy. Do you think that this level of regulation, of new legislation, is enough? What do you think? I mean, if you should somehow provide your point of view on the room for further improvement, do you think this is already a very high level of innovation for a regulation, and it was not probably at if you consider an international level properly conceived? Do you think that this is already something, and how, I mean, you see if the government will keep, hopefully using this approach on this matter? Do you think that there is still room for further improvement?
Well, I would start from saying that, in my opinion, nothing is ever enough to help companies. So always room for improvements exists. But as we were saying before, this is the first law which is almost universally considered as a true and effective help to companies after several years where no helpful legislations have been enacted. So, and it is a very good starting point. It is a very good starting point even if we consider and we compare this kind of legislation with the one that we were mentioning before, applied by other countries, such as we were saying Spain or Luxembourg, the Netherlands or UK. We were saying that in all those countries they did something similar to what we are talking of now here, but they didn't go so wide as we did. Trademarks, as I were saying, are not included in most of the legislations that we mentioned before, only in Luxembourg. So, in my opinion, always considering that the improvement is something to which we must drive, in any case, it is a very good starting point and is something that is really worth applause to our government, in my opinion.
So, hopefully, we really look forward to organize a next webinar next year with by providing some examples. This will be nice to do with some examples of companies that can experience what they've been facing in the past, and how somehow the new legislation brought some support and some effective incentives to their activity. So if we do not have further questions, I think we don't. So let me thank Francesco and Piero for being here today with us. I really hope, all the information were clear and useful for all the people following us online today. Final thing, as I mentioned before, all our webinars will be soon available on our online channels. And this afternoon in 2 p.m. Italian time, we'll have a final webinar for 2015 on real estate sector with a focus on hotel investments opportunities in Italy. So feel free to be there with us as well in the afternoon, and we will soon provide you with the calendars on the topic for next year webinars, and further information will follow soon. So thanks for your attention, and see you next.